Well, thanks everybody for joining us. We're giving this a try in COVID times to continue the mission of the Law Practice Management Group. And whether it's a good idea or not, I thought, let's have sort of a town hall style discussion on some topics, get some people in who have some experience, get questions from the audience as we discuss it and kind of see where it goes. And so that's kind of the general format today. I'm moderating this, so I'll kind of help the conversation continue with some targeted questions and topics for our three co-hosts today. But at any time, if participants, if you've got questions or your own thoughts on the subject, that is kind of the point of this format, to go ahead and weigh in. For audio quality, stay on mute unless you have something you want to say. Then certainly chime in, and we welcome that full participation. As I mentioned, my name is Mitch Peterson. I'm a partner at Davenport Evans, and I think the newest guy on the LPM committee. Joining us today to discuss Zoom mediations. Our three mediators from across the state. We've got Linda Lee Viken, Mike McKnight, and joining us soon will be Lon Corey as well, who had a little bit of a time conflict that knew he would get here partway into the presentation. I chose this topic, or at least suggested we go with this topic. We're about a year into the Zoom thing now, the pandemic, and at least personally, I've still encountered people who have not used Zoom for any business purpose, certainly not a mediation, people who still have resistance, questions, fears, and a lot of people who have embraced it. And I think it's probably something that's here to stay for a while, whether it's continued pandemic, new strains, or just the cost effectiveness meeting a technology that can actually deliver. So we got clients, adjusters, and people all over that might insist on it just from a cost perspective. So at this point, I'll go ahead and turn it over to Linda Lee and Mike to just introduce yourselves, and then we can, I guess, get the conversation started shortly thereafter.
Want me to go first, Mike? I think I know everybody on this call, so they probably all know who I am. So after 40 years of family law litigation, I decided I was only going to do family law mediation. So that's what I've been doing, and I really enjoy it. I do. I have a lot of pro se folks that I do. Sometimes it's just custody parenting. Sometimes it's full divorces, and then the traditional with lawyers as well. Mike, it's your turn.
Thanks, Linda Lee. Similar situation for me. I practiced law for almost 35 years as a litigator. Kind of flamed myself out, burned myself out, decided before I had ever heard the word COVID that I was going to leave the law firm in April of last year, April of 2020, and just do mediations. I wasn't really planning on COVID stepping up to the plate as part of that little business plan, but it did, and it's worked out fine. And the reason it's worked out fine is the ability to do mediations over Zoom. Without that, my goose would have been cooked. So I'm pretty happy that I found this technology to be able to do that. So happy to be here.
All right, and we'll let Lon make an introduction when he joins us too. But I guess one of the concerns I think a lot of people have heading into mediation is confidentiality of the process, and I think that probably more so on parties than attorneys, but I think that is compounded when you bring it to the internet and Zoom video technology, is particularly in the early days, and even currently you hear all sorts of issues about security concerns and confidentiality, people Zoom bombing and dropping in, that sort of thing. So I guess, what concerns have you both encountered as mediators from attorneys or parties on that subject?
Oh, Linda Lee was pointing to me. I was going to do the ladies first thing all day, but that's okay. I went into this Zoom thing, frankly, with my eyes wide closed. I mean, I did not even think of security issues when I first started it. It wasn't until I started to see some of the Zoom bombing stuff show up on the internet. Of course, Zoom adapted to that, as all these other platforms have as well. And I've adopted every security measure that they have recommended. And it's not been a concern. I've not had a situation where someone had shown up that wasn't supposed to be a part of the mediation. I've had a couple of times where I would not let people into the Zoom room until I knew who they were because their names weren't familiar to me. And then I find out, oh, well, that's a claims adjuster or a employer representative or whatever the case may be. But I'm pretty comfortable with where this is at right now. I don't know, Linda Lee, if you feel the same way or not.
Yeah, I think the security, if you follow the protocols, I mean, one of the things you have to do is go in and read what Zoom tells you to do and make sure that you do them. So I think the security is less of a problem than the confidentiality issue is. You've got to be careful about the confidentiality issue. You know, if you look down on your screen, you could record this unless she's got it clicked so you can't record it. Also the chat, if you use the chat, if you go over, there's 3 little dots on the other side. If you hit those, you can save that chat. So you do need to be careful about that. Mediation, of course, as we know, is confidential. So you really have to be careful about making sure that the people on that meeting understand that. I've thought about having them sign an actual confidentiality agreement. I do have them sign a mediation agreement, but I've thought about, you know, whether I should strengthen that if you're doing it by Zoom, so that they understand completely that, you know, they can't record this, they can't use this, they can't go back, and just as they can't with what happened in the mediation itself. So, you know, you just have to be careful. You have to make sure that you've got all the things in place. And the other thing is that who else is with them? I read in one of the articles I was reading that this guy does it, and he has them pick up their laptop and do a 360 of the room to show the mediator that no one else is in the room. Now, I thought that was kind of clever. So that's the other aspect of it with the confidentiality.
Yeah, and there are ways too that Linda Lee mentioned the settings that the host can set for the Zoom meeting. One of which does not allow saving of chat. If you don't want it to be saved, you can set it such that it won't be saved. I think there's a similar thing with regard to record. I've never had a situation where anyone has tried to record a mediation. I have had a situation or two where when an individual party was not in the same room with their lawyer, a couple of times have not been real sure who else was in the room with that individual party, because I could hear them muting the button and see them talking to somebody, but it was in every instance was just a spouse or significant other. So.
Related to this topic, I'm recalling, because I've got a case pending right now where there was an apparent settlement at mediation. Nothing got signed. It ended up falling apart thereafter. You know, under the Mediation Act, I believe it still states that in order for a mediated settlement to be binding, you got to have the people sign an agreement. Often I've had mediations where the mediator brings sort of a stock template agreement to mediation where you can fill in the party names, fill in the core terms, get it signed, and know that it's not going to come unraveled. How do you guys deal with that in a Zoom context? Is that an issue? And I guess what solutions have you found to be helpful?
Well, I think that is a big issue, especially, you know, in divorce cases where you have a lot of terms you have to make sure are not locked down. And that was a challenge for me at first. And then, of course, you find that there are things like DocuSign, things that you can use. I'd be interested, Mike, to know what you use, because I still do get that signature. the first time I did it, I actually emailed the document to one of the parties. They signed it and they emailed it to the other party and signed it, and then they emailed it back to me. It worked, but it took a little bit of time to do that. But yeah, if I have an agreement, I never let them leave without signing it. We all know what buyer's remorse is, and and so if they're they go talk to their friends in family law, their friends or their significant other, tell them that was a mistake and they want to stop. So but Mike, what system do you use to do that?
Yeah, I've kind of done a little bit of all of the above to some extent. I've started using DocuSign on cases where I'm going to actually, anticipate having an actual agreement, the formal document, the full and formal document signed at the conclusion of the mediation. In a lot of instances, what we end up with is something that sort of resembles what the final document will look like, but it's just more of a memorandum of understanding. We, the parties, have agreed to A, B, C, D, and E and get folks to sign off on it. Alternatively, confirming it via an email response and getting replies back from the lawyers saying, yep, we agree, this was the settlement, as set forth in the email. I've done it all of those ways. To be real honest with you, what I really like to see is folks that have taken the time in advance of the mediation to give some thought to what the terms of the settlement and what the settlement document is going to look like, so that we can have that right then and there at the mediation. Everybody can look at it. You can put it up on a screen share, parties can see it, you can make changes to it, and you can just get the full doggone thing signed right then and there. That is by far and away the best of all worlds in my mind. Sometimes it's hard to get lawyers to focus that much going into a mediation on what a settlement document will look like when they don't know if settlement is going to happen. But I tell you, it sure makes life a lot simpler on my end. And when you're done, it's signed and it is truly over.
Because with divorce cases, of course, there's a sort of standard format that you use. So I do prepare a draft one in advance, because I take the information that they give me in advance and put that into the document. And if I'm doing a video one, I will normally send that to them in advance and ask them to read it, because we're going to go over it. So then I can put it on the screen and I can go right over it and do what you're saying, Mike, and that is, make changes and revisions in it.
Yeah, and in particular, what I see, Linda Lee, in kind of the civil world where things tend to get hung up a little bit, is if you start talking about non-disparagement agreements, confidentiality agreements, what are the terms of that going to look like? Sometimes what, for example, Mitch might think it's going to look like and what I might think it's going to look like might be very well two different things, but that really helps, and it saves a lot of time on the back end. You don't want to put in all this time getting an agreement negotiated only to find out that now you're going into round two negotiating over what the terms of the confidentiality or non-disparagement or whatever are going to be.
The devil in the details, you mean?
Yeah, absolutely.
Yeah, I think that's really important to do that. And I found that it actually worked better than I thought it would. I do, as I said at the beginning, I do a lot of pro se work. And so those were a little trickier to do on Zoom. If it's custody parenting time, especially, that's a little trickier, because I think having them in the room, in the same room, is helpful, at least for part of it. But it worked all right. I've done that and it worked okay.
One last thing, Mitch, and it's not maybe necessarily related to this, but it kind of gets back to the confidentiality piece as well as to some extent this, but I've gotten a lot more picky about getting people to sign my mediation agreement going in than I was in the past. That's a result of a couple of things. There was a Supreme Court case a few years ago. Linda Lee knows the name of it, Weingarten, I think, or Weingarten, something along those lines. But
I think that's right.
yeah, you know, and I get some eyeballs rolled at me when I insist on a lawyer that I've mediated for 24 times to sign my agreement, but I do it for a purpose. It's to protect the parties as well as to protect me with regard to that confidentiality piece. And so I've gotten tighter on that as a result of the Zoom stuff too.
My mediation contract form has a place for the lawyers to sign as well as the parties if there are lawyers involved. And that has to be completed when we start, if it hasn't been sent to me already.
Yeah, I'm pretty accustomed to having to sign as the lawyer. I mean, I never signed settlement agreements, but yeah, the mediation agreements, I think that's pretty ordinary course, and I think any resistance probably is not terribly reasonable. So, kind of on that subject of, you know, getting, I guess, some of the non-monetary terms figured out in advance, whether it's non-disparagement, confidentiality, those sort of things, document retention. What other advice do you have for, I guess, the lawyers as well as parties in terms of getting ready for mediation that might be unique when you put it in a Zoom context where you got people not in the same room? You can't drag your banker's boxes in and give that to the mediator to run to the other room. So what sort of unique advanced preparation have you found to be helpful to either have lawyers or parties do before the mediation starts?
Go ahead, Mike.
I knew you were going to say that, by the way. I could tell by your look that was happening. I think, Mitch, more so maybe than the old-fashioned way of people being in the same room. Like you say, you know, on Zoom, you're not going to pass a document across the table to the other side. You know, it's really important that information be exchanged in advance coming into that mediation, particularly if it's on Zoom, because it is going to be difficult, cumbersome, you know. In order for me to share screen, and incidentally, when on my settings, I will allow all the parties to share their screen to do that if they wish. But in order for me to share that screen that you're showing me in caucus, and for me to share that with Linda Lee when I go in and caucus with her, I have to have that document on my computer in order to pull that up and to be able to share it with her. And so I think the sharing of the documents is really important in the Zoom context. I think it's important in all mediations that there's been this free flow disclosure of information. Nothing sets a mediation back farther than somebody getting a really important document for the first time in a mediation. You know, it's like, whoa. You know, I mean, your first reaction as a lawyer is to just say, well, hang on, man, I back off a little bit. I need time to sort this out. You know, it may not be that crucial of a document, but that's going to be your first reaction, right? So I think that's really important. I think preparation and preparing the client for that Zoom mediation is equally as important, so that they know what to expect. And are they going to be in your office with you? Are they going to be at home on their own computers? Do they know what is going to happen? You know, I try to send out I remember what I call it now, online guidelines or some such thing to people, so that it kind of spells out what's going to happen. You know, we're going to all get together to start, but then we're going to be put into breakout rooms and that kind of thing. I think clients need to know those kinds of things in advance. You know, it's not as easy as just having them show up that day in your office. It takes a little more effort, I think, on the lawyer's part.
Mike shared that document with me, and I do use it. You can send it out to your participants for the Zoom meeting, and it tells them what to do and how to prepare for it, and you know what buttons to press, kind of thing. Of course, family law is a little more defined as to what issues we have to deal with. Though, of course, they vary by factual differences. So in advance, I always ask for materials to be sent to me. And then, for example, if I'm doing a full divorce and I get two sets of values, I'll actually put those into one document. And then I'll share that before the meeting with them. And there's also standard language I like to use in custody parenting cases. And so then I also will put that, I'll also send that out in advance for them to read so that they're prepared. Because it is important, even if you're going to go over it there, that you have that information out to them. And you've got to be prepared to answer their questions sometimes before even they'll have questions. But yeah, it's the documents are, if you're going to have them sign it, you need to get as much out in advance as you can. And also, of course, if you're going to share your screen with something, be sure you also have a PDF copy of that you can send to them when it doesn't work. and you can't get it up like I had at a presentation I was doing. It wasn't a family law meeting, but I couldn't get my PowerPoint up. But luckily I had sent it to the person who was leading the meeting and he pulled it up on there. So, it's nice little surprises that you get in life.
And along those lines too, I think it's really important because it can get to be really confusing when you're talking about different drafts of documents, and particularly if you are on Zoom. I think it's really important to date and number those, draft number 2, draft number 3, whatever. So, everybody knows what we're operating on. It gets kind of balled up sometimes in the Ethernet here to some degree. And if anybody wants me to send them a copy of those online guidelines, I'm more than happy to do it. Just shoot me an email and I'll get it to you.
Yeah, I'd like a copy. I think that'd be good to share with clients and other members of my office. So yeah, that'd be helpful, Mike. Mike, you'd mentioned something, whether the client's in the same room with the lawyer, sometimes the client's at the client's house, the lawyer's in the lawyer's office, and they're not together. And for both of you, I guess, I've been in some mediations or depositions or just video conference meetings where 2 or more people are on one device. Do's, don'ts, etiquette. What are your thoughts?
Yeah, that that can be a little bit of a problem. And I was telling somebody just this story the other day where, let's say client is in with lawyers in lawyer's office, and instead of moving the camera back and forth, the lawyer just sort of splits the difference so I can't see anybody, which really it's not a good situation. But, sometimes that's the space just kind of dictates that. But ideally, if they're in the same room, I like to be able to see both the lawyer and the client. And, even though we might be hundreds of miles away and we're on the internet, I can still read a lot by what's going on just by kind of watching that interaction. Even if people aren't saying things, you can still pick up a lot of tells, so to speak. But yeah, if you're stuck sharing the same device, then move the device back and forth so I can at least see each participant in full. A lot of law firms here of late have come up with some really, really nice Zoom rooms where, and I see Sarah Show is on. I'm thinking of the one over at her office that I know she was involved in putting together, but that's a really nice Zoom room. I mean, the picture is such that you can see the conference room table and you can see both sides of the table and you can see the lawyer and you can see the client. And I mean, it's just really a good setup. One of the biggest eye openers to me when about a year ago, the first Zoom mediation I ever did was how poor lawyers' technology was back at that time. One of the first Zoom mediations I did, the lawyer didn't have either a camera or a microphone that worked on their computer. So we basically ended up doing it. That person was on the phone. The other lawyer had a good setup, and so they were on Zoom, and I'd talk to them on Zoom, and then I'd click them off, and then I'd dial up this guy's cell phone and talk to them, and it was like, oh man, this is awful. But Technology has gotten better with lawyers, and I think lawyers have gotten better with technology.
I think, of course, many of mine, the pro se ones, obviously there'll be only one person on there, but I've done them with the lawyers, and they usually just they can put it in a way that I can see both of them. I had one time where the person was the client was way in the back and the lawyer was in front, and I asked them to move the client a little closer so that I could see them. And I do think that one of the problems is the technology differences. Of course, both at home and at my office, the internet can get insecure sometimes, and I just really love that when that happens. And you're going, and you haven't caught up with your voice yet, so not much you can do about that. But that is something that has to be really, you've got to make sure you've got the connections to not have that happen.
And one thing along those lines, Linda Lee, and I'm sure you've probably had to do this before too, where you've got an unstable internet connection in somebody's office, and they can't, they check out, so to speak. Zoom is set up so that you can dial in on those telephone numbers. You can call in, it's audio only, but you can still be placed into a breakout room even though you are calling in audio only. And I think a lot of people don't realize that, and it works, just as well. I mean, I'm not seeing who it is, but at least that connection is not as unstable sometimes as internet is.
Mike, you had mentioned the very first Zoom that you did. You got someone, it was a disaster. They had to get on the phone and you had to call. Like how have your experiences been when you kind of have a mixed bag, where you might have a couple of people on site, you might have someone on the phone, you have 2-3 people on video. Like how do you make that work? And has it worked? I mean, that's, I guess, one question. So I've had some resistance to mediations where it was going to be a mixed bag, and I said I think it'll work. We're trying it next week, so we'll see. But I'm just wondering what your experience has been like, and whether that's effective to kind of use a patchwork approach.
Yeah, it's not ideal. I'll certainly give you that, but it's like everything else in life. If you want it to work, you can make it work. No question about that. One thing that is problematic, and I just did one of these, it was a couple of weeks ago, where I was in the same conference room with a lawyer who was there in person, but their client was on Zoom, out-of-state client. And so I was the host, right? So I had to set up the Zoom meeting. And so I was literally across the table from this lawyer who was on the Zoom with a client who was also on Zoom. And I thought I was going to jump out the window because the feedback was so bad, it like drove me insane. But I ended up just turning off the volume on my computer, and you made it work. Yeah, I mean, it's not ideal, Mitch, but you can make it work. And I have not had any. I mean, it's not like I can tell you that, oh, well, that case didn't get settled because somebody was there in person and somebody was on Zoom and somebody else was on the telephone. You can make it work if you want to.
I haven't had a Zoom meeting that way, but I've been in meetings where they have people present and by Zoom. And the difficulty can be if you want to do something together, because they can't see each other. You have to take a computer and put it up like this, so that they can see it on the screen. So it wouldn't be exactly ideal, I think, to try to do that, but sometimes it's necessary.
On that subject of, Linda, you just mentioned, seeing each other and being together, and Mike, I think you talked a little bit about, tells and body language. How do you connect? And this is, I mean, probably not as mediation, but it's, something we all deal with, whether it's trying to get a feel for a witness that's on the other side of a Zoom or a Skype. What's your experience been like trying to make that personal connection, and in a video conference?
Well, I haven't really had difficulty with that. Maybe because of the nature of my topics, you know, since it's a more sensitive thing, family law cases are, but it does take time, you know. I do a general one together, and then I do them separately and talk to them. And then that separate one, I think I can get a better view of what they're like. And sometimes I just have a little conversation with them, you know, tell them some things about myself or ask them some questions just to sort of feel that you connect. You know, some people say, well, you know, it's bad because you're not in the same room. You know, you guys are closer to me right now than you would be if I were in the room with you. I can see your face, you know, and your actions better than I could if we were sitting in a room and I was sitting across the table from you. So I don't know, Mike, what's been your experience in that regard?
Yeah, you know, and I mean, we've got completely different types of mediation practices, but I have the same impression, Linda Lee, and I don't treat it any differently than I would if I were in the same room with people. One thing I've always said about the beauty, and it kind of becomes a challenge to me in mediations, but there's very little. I mean, if it's somebody from South Dakota, within about 4 or 5 questions, I bet you I can find something that we have in common or someone that we have in common. And, you know, one of my former partners used to say, if I don't know somebody, give me a couple phone calls and I will. And it's very true in South Dakota. I have not had any issue with making a connection with anyone. I treat it just like if we were there in person. And I have done a number of mediations where the plaintiff was non-English speaking, and that's equally as difficult on Zoom as it is in person. I mean, nothing really changes there either. So I don't really notice. I think you can still connect. Again, if you want to connect with somebody, you can. It's not that hard.
What
By the way, I call that Dakotativity. That we're only two people away from each other. I may not know you, but I'll know somebody that you know.
Oh, I tell you what, I could go on forever with war stories about this, but I did a mediation about a year ago, and I won't bore you with all the details, but I actually played high school hockey against this guy growing up in Minnesota. So now that was a stretch to get that far back, but you can do it if you try.
What is demand for video mediations been like in recent months, now that places are getting a little more back to normal, people are getting vaccinated, people are just sick of the whole COVID thing, whatever the reason is? How has demand been like recently?
I've been surprised by that, Mitch, because I have been scheduling mediations, you know, late April out into May and June, and the parties are still requesting Zoom, which surprises me. I literally this morning had my second Pfizer vaccine. I mean, I've graduated from the vaccination program now, right? but people still are doing the Zoom thing. I think they like it. I think they realize, and the clients realize, how much money it saves. Ultimately, you know, I told Linda Lee this the other day. I'm going out on Friday to do a mediation in Rapid City with 2 very experienced workers' compensation counsel. And I said, guys, why are we doing this in person? This makes 0 sense. You know, it's going to end up costing a couple thousand to $2,000 to $3,000 more. And they still wanted to do it in person. I'm not entirely sure why. Maybe they just wanted to see my smiling face. I don't know, but I'm surprised that the demand is still there.
I think in family law, at least my experience recently, they kind of like to do it in person more than by Zoom, unless they don't live here. I mean, I've had one recently where the the husband lived in North Dakota. And so then we did it that way. But because of all the documents that they have to sign, I think it's sometimes easier to do it in person. I'm happy to do it either way. I give them an option of which way they want to do it. And some of them don't have the equipment at home or are concerned about, about how to operate it and everything. So they'd rather do it in person. So, and Marilyn, we should have had her comments earlier when you talk about how to get documents signed back and forth because of what she's doing with pro se people. Because she has some great things she's put together.
Mitch, the other thing that's a benefit, and it's a benefit that can't be overlooked, is that I have the level of insurance company claims adjuster participation in mediation has dramatically increased since we started doing Zoom. You know this from your practice. I mean, it's hard to get an adjuster to walk across the street sometimes to attend an in-person mediation because their company policy won't allow it. But I routinely will get participation from adjusters on a Zoom mediation, which is invaluable to the process.
Yeah, or at least in recent years when I've had adjusters either on my side or the other side. I mean, I've had one adjuster show up for mediation in the last decade, and maybe longer than that. It's almost always by phone, and then they're not engaged throughout the day. They pick up the call, whatever. They're already in their own mindset, and then they're back to the next thing. And you call them again in an hour with an update. They don't stay part of the process, and that's really important. Otherwise, it's just the mediation process doesn't really ever have a chance to work if they're not part of it. But yeah, I've found it, at least with Zoom, there's some accountability. They're on there, and I look at this just in a related context with my church, which has just recently gone back to in-person services. We've done the pre-recorded, put it on YouTube, and like I can count on like one hand how many services I've went back and watched. But when we've had like a Zoom service, there's that accountability that you're showing up, people can see you, you can see them, they know if you're watching, they know if you're tuning out. So there's probably some value in that. I think that's a good observation, Mike.
Well, and I had early on in the Zoom world, I had lawyers tell me, it's just too easy to disengage if you're not there in person, and people can just too easily walk away, et cetera, et cetera. And I would argue that at least insofar as these insurance people are concerned, it's a lot harder to disengage if they're actually participating on Zoom. We've all had those experiences where you're trying to, I need to talk to my client. They gave me a phone number. They're available by phone. And then, 2.5 hours later, after they've had lunch and watched their kids play soccer and do whatever else, they get back to everybody, and this is different.
Well, I wanted to, we had, just to be respectful of people's time, we put a hard limit on this event at 60 minutes, but I wanted to kind of wrap it up by 45 just to have an opportunity for participants, if they don't feel like they've had a good opportunity to chime in or ask questions, to do that. So I'll go ahead and open it up if anyone has questions, comments, your own observations, different takes on things. And if there aren't any, I guess we can.
I have one. Mitch, Bob Morris. For both Mike and Linda, what's the biggest reason any mediation in your mind fails, whether it be Zoom or otherwise?
You want me to go, Linda Lee? All right. In my experience, Bob, it's lawyers not having set their clients' expectations properly coming in. And that works on both sides. Of course, it's easier if the plaintiff has higher expectations and I can work on them as a mediator during the course of the process because they're physically present. But if it's an insurance company and they're not physically present and they have an expectation of what this case is going to settle for, I have got zero chance of changing their mind in a mediation. It's expectations, client expectations, in my view.
I think that it's a little bit dependent upon if the attorney has really gone in with wanting to get the case resolved, because obviously, you know, we can't give their clients advice; they have to do it. I find sometimes just meeting with the attorneys together and having a conversation with them about what's going on. I always like to start out with, okay, here's what I think that the issues are. Tell me if I'm right or wrong about that. I've been fortunate that most of them have reached agreement, but it's a combination, I think, as Mike says, about the client and the client's attitude. Has the lawyer prepared the client that this is really about compromise? We are not going to come out with everything that you would like us to have, because we might as well go to trial if we're going to try that. So I think it's really a question of, has the lawyer prepared the client to understand the process? And that's why at the beginning, I'm sure as all the people who've done mediation do, we start out with talking about that. And I talk about, in my case, I can say, well, divorce cases are those with the highest amount of discretion that a judge could have. So you have lots of, this could happen, this could happen, this could happen. But I think that's the reason that would not be successful.
One other point, something Linda Lee just said reminded me of this. You know, I think a lot of lawyers go into mediation thinking that this is it's like a trial and it's going to be a win or a loss. And mediation is not a win or a loss kind of situation. It's a different mindset. And I think as advocates for your client, I think you have to appreciate that it's a different mindset, that we are not going to go into this and win. That's not how this process is set up. Linda Lee does not make the decision who's right or who's wrong, who wins or who doesn't. It's not a win or lose kind of a situation at all.
The win is getting it over with. is being able to walk away and say, I'm done worrying about this.
You know, and I think along those lines too, the expectations and properly preparing the client, I think also should include in every instance, not only a description of what's going to happen in general terms, but a description of what's going to happen maybe in more specific terms. And by that, I mean this: explaining to the client going in, you know what, Mitch, there are going to be times in this process that you are going to be very frustrated by what's going on. That's not peculiar to you. That is peculiar to the process. It's going to be a frustrating process. Don't let that frustration get to you. You know, those kinds of things are things I think the clients need to know and understand going in. It makes it a better situation for them. As lawyers, we all become very accustomed to this process and what we do and what it's all about and how we do it. It becomes old hat for us, but it's not for the clients. This might be their one and only time ever to participate in it, and we owe it to them to explain the process to them.
You know, on a related note on this subject, you know, most of the time when I deal with opposing counsel, we're both in our, you know, advocate mode, and I always, at least I think, I put on my advisor hat when I'm talking to my client, and I think, or at least hope, that that's going on the other side. But when you have a lawyer truly, I mean, their advisor hat was lost years ago. I mean, it's under a couch somewhere. They've never worn it. They never take the advocate hat off. how do you break through that? I mean, that is, I don't know, just looking for your recommendations, because there's times where I suspect that goes on, and maybe that's what mediation is for. So I at least know somebody else is talking to the client on the other side, other than the advocate. I don't know what your thoughts are on that.
Well, usually we know the lawyers that we're going to be dealing with, so we know their personalities. So sometimes a little conversation before you take on the mediation with them about, what your expectations are of them, can prove to be beneficial.
Go
I
ahead.
was just going to say, because otherwise they won't be having me as a mediator, or I won't be taking them on another mediation.
I love it when lawyers call me ahead of the mediation to just talk heart to heart about what's going on and what to expect. And that's not a ex parte contact. I'm not a judge. You can call me anytime you want. We'll BS about all kinds of stuff to include your case. I'm fine with that. I also, I will, more to your question, Mitch, I tell both sides that while I am a neutral party, that doesn't mean that I'm passive. And I'm not going to just sit there and just sort of passively ignore the facts and paint a rosy picture. That's not what my role is. Part of my job is to facilitate the discussion, certainly. I set it up, right? I got everybody here. But the other big part of my role is to provide some evaluation to the parties and the lawyers. And in doing that, I'm going to have hard conversations with people. And they're not going to like it, but that's me doing my job. They don't have to listen to me, but
they're paying you. They might as well listen to you.
I think oftentimes the clients do want to know what your thoughts are of this process. I always, if I'm in a room with the attorney and their client, the client asks about that, I never respond without, I say to the attorney, do you want me to answer that? And they usually know how I'm going to answer it. And sometimes it's like, yes, please answer it. They don't say that, but they say it in their eyes. They just want, the client's going to hear the same thing their lawyer's been telling them.
And this gets back to something we talked about a little bit ago, but I really do like to get the lowdown from lawyers going into a mediation, right? And if Linda Lee's thinks her client is a giant dirtball and horrible, terrible expectations, whatever, I don't want to have to spend half the day trying to figure that out on my own, or try to figure out whether Linda Lee knows that her client is a lying sack of goo or whatever. I'd like to know that coming in. It helps me as a mediator coming in. And I really do appreciate talking to people in advance.
I have them do a confidential statement the lawyers also send to me, and they know that they can tell me, they know me well enough that they know they can tell me in there that, that there's a problem here, or this is a real concern. Because I ask them that, what are the concerns that your client has? Or I just sometimes say, what's your best and worst scenario?
Bob, thanks for that question. Does anyone else have any questions or anything to add to the conversation?
I had a question. So I had, with the Works program, I had a pro se mediation not too long ago where the person was drinking one of the people on the other side, and became more and more difficult as the mediation went along. But it was a mediation where there was it was a court-ordered mediation. So how would you have handled something like that, or just any tips you could provide?
Sure. Thanks, Mike.
I was giving you the finger.
Oh yeah. Well, thanks. We're blocking you off now. Well, I was trying to think what I would do if I had that situation. I mean, obviously you can't continue to do the mediation with them because you are they a firm, and however that is, sane, are they sane, able to make decisions? And I suppose that you'd really have to just say, we can't go forward with this at this point in time. I don't think you're hearing what I'm saying, and then you'd have to notify the judge, I guess. You could reset it. I mean, you could say, we're going to discontinue this now, and we're going to do it at another time and set the time with them.
I think the fact that it's court ordered adds a wrinkle to it that, doesn't ever exist in my world. But I had a situation several years ago, in-person mediation, where the plaintiff was his own worst enemy. He ended up leaving mid-morning. I'm convinced went out and smoked a bunch of meth and came back and was just a complete horse's ass when he came back. And we just pulled the plug. I mean, partly my decision, partly his lawyer's decision, but we just said, this is not going to go forward. I mean, I think, Marilyn, it would certainly be within your rights in that situation to just say, yeah, we're done. We're going to have to reschedule this.
Thank you. That's basically what I did. And then I told the judge, I didn't tell the judge about the exact situation, just that I felt we would need to reschedule. But I was curious how you would handle that. Thank you so much.
This is John Blackburn. I just want to thank our host, Mitch, and our two mediators. I think you've all done a very good job, and I was going to email you and say so, but I'm saying so now. Thank you very much. It's been helpful.
You're very welcome, my friend.
Thank you,
Thanks,
John.
John.
Nice to see you.
And all of you, I miss seeing the lawyers a lot. I'm probably one of the oldest guys still practicing, and hope it isn't all that evident, but God, I enjoy the bar conventions and getting to see all of you people. Enough is enough. Thank you.
Well, that's one thing about the Zoom meetings I do appreciate, even though they're difficult sometimes. At least when I see you in person, I mean, if you thought to yourself that no Zoom meetings were possible during this, think the difference that it would be to you to not have even seen people for all this time. So at least I think they're good for that reason too.
Well, I just wanted to again thank Linda Lee and Mike for sharing their time with us today and answering questions, providing guidance on these subjects. And if there are no further questions, we'll go ahead and adjourn the meeting. Thanks again.
I think I speak on behalf of Linda Lee as well. Thank you all for giving us this opportunity. And I truly mean this. And if anybody has any questions or wants to talk about it further, I'm happy to answer questions. And I know Linda Lee would be the same.
Sure. Yes, thanks for the opportunity. I won't say thanks for having me on because it drives me crazy. Thanks for the opportunities for this presentation.
All right. Thank you all. Take care.